We will be recording today's webinars, and you will be able to watch that later at your leisure. I'm Gina Sudam. I'm the president of the Wyoming County Chamber of Commerce. Thank you all for joining us today for what I think is our 5th installment of Restart, Rebound, Rebuild. This webinar series has been extremely successful for us in helping to inform all of you about the current happenings in our world right now. I hope that this morning you and your families are all safe and healthy. And without further ado, we will get started. As you can see on my screen, our today's session is employment law and group health benefits. I was corrected by my new attorney friends that labor law means something different than employment law. So I did change my slide, and I would like to I'll quickly introduce our speakers for this morning, and then we'll get right into our Q&A. So we have Bill Aquilino on the line. He is with Checkmate Consulting. I just met Bill a few days ago, not in person, of course, but via another Zoom call, and he was gracious enough to help us out this morning with our questions. We also have joining us this morning all the way from Massachusetts, we have Steve Torres. He is with the West Group Law Firm and comes to us as a partner in the firm with Bill Lawrence, who is a board member. So the West Group Law has a practice in Wilkes-Barre as well, but Steve operates out of Massachusetts. So good morning to you. And then last but certainly not least, we have Colin Healy, who's a longtime friend of the Chamber with the C3 Group. And Colin knows all about employee benefits and human resources and is going to help us out when we get to our group health benefits portion of this morning. And I will get right into it. So I have a list of about 10 questions on employment law, and then we'll get into group health benefits. And I'm going to start off with Bill. So if you would unmute yourself. And here's my question for you. What may an employer do if an employee states they feel unsafe returning to the workplace, assuming that the employer has taken all recommended state and CDC precautions?
Thanks a lot. And first off, good morning, everyone. I hope everyone is happy and well and making the best use of time with their families and loved ones. This is actually one of the top 2 or 3 questions that I get in my practice from facilities big and small. Stepping back and taking a look at the 30,000-foot view, if you're talking about at-will employees, then generally the employer has the right to modify the scope of employment of that employee. And the employer could, for example, make or allow an accommodation for the employee to work at home or remotely. One of the other things that I've suggested that people do is have those employees work in an isolated area of the facility, or if nothing really can be done to satisfy the employee, have the employee take a furlough. I'm guessing that the real import of this question is, what can I make the employee do? And I think there's an objective and subjective component to the analysis. If you've taken all of the state and CDC precautions for cleanliness of your facility and minimizing cross-exposure, then there really is a minimal risk. Of course, you would want to change or modify that analysis if you had an employee who was at high risk, or your facility was at high risk. For example, you're in a nursing home, or you have a lot of contact with the community. For example, grocery stores are open. If the objective standard is met, then you could possibly treat this as if the employee is refusing to return to work You could have the employee take a paid vacation. You could use a furlough or anything else that's identified in your employee handbook. One of the things that has been coming up repeatedly is employers are looking at their employee handbooks for the first time in a long time. And one of the things that employers should do is take a look at that handbook and make sure that it has a safety valve either in the job description or the employee handbook for allowing or requiring employees to work at home during emergency situations, or who the essential employees are who do have to come to work based on job description, regardless of emergency situations.
Great. Thank you, Bill. Those are some great tips for us. And I hope we all are looking at those employee handbooks a little more closely these days, and certainly utilizing the resources you have available to you to update those if need be. Our next question, we're going to go to Steve. And Steve, can you unmute yourself? All right, we got that. If an employee contracts the coronavirus at work, am I financially responsible for their medical bills?
So this is a very good question, and it dovetails into a general point that I wanted to make when I looked through all 9 of your employment side questions. With some of them may be labor side questions only if you have collective bargaining agreements in some of your member groups here, which most likely you probably don't with small employers. But the background, you want to look at the entire COVID response and the entire regulatory changes and the entire statutory additions that have been made in response to the pandemic, the existing labor and employment law, the existing workplace laws that are already in place. They're not supplanted, they're supplemented by these things. So we have to think in that context, in that the Americans with Disabilities Act, the Family Medical Leave Act, the state versions of those acts are still in place and are either supplemented by the law or in some cases, there is language that makes exceptions that weren't there before. And this is obviously one of them, but it's grounded in the foundation of your law. The foundation of workmen's compensation law is that if it's an occupational injury or it's a workplace injury, an occupational disease, a workplace injury, then you are compensated under the unemployment law. You get the 2/3 of your salary, you get 100% of your medical benefits. You don't get to sue your employer for pain and suffering and other things. You get to follow the act. You get the benefits that are there, but as this begins to unravel, because it's new, you're going to see new presumptions that are implied. You're going to see an unraveling of where occupational disease separates from an occupational injury as a result of exposure to COVID. So it may be an occupational disease in the sense that you work in a pharmacy or a medical practice or a place like that where the hazard would be beknownst to the employer. It would be an injury if the employer were negligent in not providing you with PPE at the grocery store, knowing that the grocery customers may come in unprotected and provide you with it. So it supplements what you're familiar with for unemployment compensation benefits, but we will have to unravel which is which with respect to the qualification of the disease, the causation, the certainty. How do I know you got this from an employer? I started quite a discussion here, and I practiced in a number of states, Massachusetts being one of them. A large discussion I started up here in Massachusetts because they wanted to add on to the injured and duty leave for first responders like police and fire with the presumption that if you get COVID, it happened at work. And some of my colleagues in the city attorney industry wanted to buck that change in the statute and not give them that presumption. And it started a large discussion up here on that because these presumptions, some are fair, some are unreasonable for certain employers. So that's where the unraveling will take place.
And then, do you know, does the employee have a right to claim workers' compensation if, again, they contracted the coronavirus at work and that is proven? And then what does that do for the employer's workers' compensation expense?
It's
right.
if it's determined to be a workplace injury or an occupational illness, it will be the same.
So that would significantly increase then their workers' comp expense.
It's claims related. And if these pandemics continue in the future, or they learn from these pandemics, then the folks that do the accounting, what we call the risk managers and the actuaries, are going to start accounting for these in your rates.
Okay.
That's what we're going to see in the long run. In addition to direct reimbursement to the system, you're going to see rates that are based on these type of workplace injuries in the future.
Great, thank you. We're going to move back to Bill and ask him about, do employers have to pay their employees the same hourly rate or salary if their employees are working at home?
Thanks, I had to unmute myself.
Yes.
The answer is a definite maybe. It really depends on the job function. There are a lot of factories and machinery shops up in my area in Lackawanna County. We have a number of industrial parks, and I think plastics manufacturers, for whatever reason, were excluded from the shutdown. What companies are doing are keeping limited numbers of line workers in the factories and paying them the same hourly rate, or in some cases, additional overtime as a concession for them being exposed to possibly COVID or increased working conditions, number of hours, stress, things like that. The reason I gave it a maybe is because it really depends on the situation. There are a lot of workers who can't perform their functions at home. For example, those machine workers, those line workers, they can't take their machines home and work on them. So if they haven't been furloughed, they may be doing additional office work or compliance work. It will depend on the number of people that you have in your business. For example, if a line worker is making $20 an hour and you switch them to an office type salary, or excuse me, an office type job duty, you would hopefully pay them the same hourly rate as the office type worker. If they can fulfill their complete job duties at home, for example, someone who does accounting and maybe uses an online program, they're in the office for convenience and for cohesion within a group, for meetings and things like that. If they can do that at home, then there really wouldn't be any legal justification for reducing their pay. If the job duties can be significantly modified so that the remote job is substantially different than the on-site job, then you can justify salary reduction or maybe even increase depending on the situation on a temporary basis. One of the things that, again, these types of crises make us think about, is this a worker or a class of workers that could be or should be furloughed? You want to make sure that you're not making special exceptions for specific workers, because then you can get into other issues about treating similar classed employees different, and then all the other employment law type of issues like disability, race, religion, gender, things like that can crop up.
Great. Thank you, Bill. I appreciate that. We're going to move back to Steve with a question about a small business owner. So if I'm a small business owner and I maybe have a couple of employees, but I get ill with COVID as the small business owner and I need to shut down my business, what should I do about my employees, assuming, again, that the business has to be shut down, and can they collect?
Again, this is a good, yes, and you know what, even pre-COVID, had the business shut down, they would have been able to collect. The addition with COVID is now in this Response Act, in the CARES Act, and in the amendments that just came through with as we speak, you're going to be able to have private self-employed business owners, if they can establish that that was a primary source of their income, eligible to collect unemployment. So not only the employees, but the employer in that case. will be able to. The unemployment law does not differentiate as long as you meet the standards between if you're shut down because of an employer's illness or if you're shut down due to, a WARN Act requirement.
And in this situation, Steve, would both the employer and the employees be able to receive the additional $600 a week from?
The employees would. The
employees.
employer, I'm not sure on the employer.
Okay.
That I have not seen that addition in the statutory language that I've read in the policies.
Okay, great, thank you. We're going to stay with Steve and ask him a question. Due to COVID employers having loosened their attendance policies, what should employers do to prevent employees experiencing serious illness in the future from expecting the same forgiveness?
That's a good point. And this is, COVID is the exception to the rule. If you notice there in a lot of the regulations and the policy changes that have come down, they're specific to COVID response. For instance, if you're symptomatic, you're required to stay home. We all know that normally when we're symptomatic with the flu or the common cold, we're not required to stay home. We can go to work. Your obligation is to, call your supervisor with COVID. Your obligation to get a medical clearance to come back to work is specific to COVID. That's not common with the regular flu and the other non-occupational diseases that are common in the workplace. So this is a new set of rules for COVID. When COVID goes away, we return to the old set of rules. And the old set of rules should be clearly outlined in employee handbooks. I know a lot of employers, smaller employers don't use employee handbooks. When you're in an employment at will state like Pennsylvania, where you can fire an employee for any reason or no reason at all, as long as it doesn't violate public policy or a federal discrimination act, the employee handbook provides a source of rules and benefits. It doesn't prevent you from terminating them, but it may justify their claim for unemployment if you discharge them in violation of a rule that you usually apply. For instance, if you have to have 3 unexcused illnesses before you're terminated, and the first time they come up, they get 1, they're getting unemployment. So the important thing is to have a good set of employee policies and follow that consistently. What we talk about is they're uniform, they're widely disseminated to the employees, they're readily known, and they're uniformly applied. And that is how, when we come back to the normal, God hope we come back to the same normal, not a new normal, but when we come back to the normal, you can enforce the rules in those employee handbooks and your regular policies. There are COVID-specific responses, but such as clearance to return to work, but those are not going to be in place when COVID goes away.
Great. Well, thank you. I appreciate that. And again, documentation, we've heard that in all of our calls that we've been talking about COVID, but document what you're doing on your loans and how you're spending your money, but also how you're treating your employees during this time. Bill, I'm going to move back to you and ask, if an employee is diagnosed with COVID, are they required to inform their employer?
This is a great follow-up to the question that you just asked, Steve. And I want to echo something that Steve said and that you emphasized, which is now is the time to check your documentation. And more importantly, what Steve said, that the documentation in a vacuum isn't helpful. It needs to be widely disseminated. And as soon as COVID hit, that was the time to get all of your policies and procedures out to your workers, so that was the first opportunity to answer questions. I'm getting a lot of these questions because I don't know how great a job, for example, the Commonwealth of Pennsylvania has done with disseminating COVID information. Most people are getting their information from, for example, Governor Cuomo. He has his daily briefings, the president has his daily briefings, but they're not really specifically related to things like this. And this question and a number of questions that have been asked are really answered by the bulletins that the Pennsylvania Department of Health and Governor Wolf have issued. So the answer to the specific question as to whether or not they're required to inform their employer, the short answer is yes. The April 15th order of the governor of Pennsylvania requires that anyone who's sick, especially anyone who's been formally diagnosed with COVID, they're required to inform their employer, and they are required to stay home. And once the employer gets that information from an employee, there are specific things now that the employer has to do. And I won't go through them all. It's a CDC document, and there's 2 orders applicable from the Pennsylvania Department of Health. But basically, some of the things that employers are required to do is ventilate the area where the employer worked for 24 hours, identify all the people who have had contact with that employee, and contact is defined as being within 6 feet of that employee for a period of 10 minutes or more. Let those people know that they've been exposed to a person who potentially did or did test positive for COVID. And then there's a whole panoply of things that you have to check off. But the burden is on the employee, certainly, to identify. And then once the employee has told the employer, then the burden switches to the employer to do a whole host of things to protect the other employees and protect the other stakeholders and people that have had contact. One of the things I was thinking about doing, Gina, is sending you the links to the specific orders that we discuss today, so that you can post them on the website, or maybe I could post them on my website. But they're pretty simple, pretty cut and dry, step by step.
Great, and I would appreciate that. When we post this recording, we are posting resources that we have mentioned. Cool. So if either of you have referred to something specific that you'd like me to post, please pass that along via email, and I would be happy to do that. I think you answered our next question, which was, if an employer is notified that an employee has tested positive for COVID, how should they inform the workplace? And this really went to the question of, can they name the employee by name as a management team?
Echoing something that Steve said, the COVID response issues are really superimposed over the laws that we had pre-COVID, to the extent that we remember them all. And obviously, an employer can't violate HIPAA. You wouldn't want to be in a situation where you're breaching employee confidentiality, for example, whether it was, some other communicable disease. Those people are in protected classes with respect to disabilities. So the best thing that you can do is just inform employees via email that they were possibly exposed, and that they should seek medical advice, and that there's going to be a protocol in place for people returning to work. Again, if you go back to that CDC order that was captured in the Pennsylvania Department of Health and Governor Wolf's order, there are certain protocols for returning to work. You have to set up the temperature tents. Maybe some of you have seen them. Anyone who has 100.4 temperature or higher has to leave the workplace or won't be admitted into the workplace, and you can only return when you've met certain medical criteria. But employee confidentiality and the confidentiality of protected medical information has to stay in effect.
Great, thank you. Steve, I'm going to jump back to you, and I'm being aware of the time, but Colin, your piece is so important, so we will get there today. And Steve, the question I have for you is, may an employer send home an employee involuntarily if the employee has symptoms of COVID?
Absolutely. In fact, and we talked a little bit earlier about the liability with respect to occupational diseases and workplace injuries. When it comes to workplace injuries, one of the questions is whether the employer was negligent in treatment of the employee, or negligent in exposure of the employee. So recall, and Bill and I have both spoken about the overlap of state, federal, and existing laws to the COVID response laws. And one of the existing requirements of OSHA is to provide a safe place for workers. One of your requirements in Pennsylvania with respect to the Workers' Compensation Act is to provide a safe place for employees. That is considered a duty when we talk about negligence, although you can't sue the employer for negligence. Negligence is a standard we apply in determining workmen's compensation claims with respect to whether or not the employer has violated its duty to provide a safe workplace. And if they do not, then in fact, they're negligent and they're liable. So the corollary of that is, yes, I have to send the employee that provides the risk factor for the other employees home until I get the medical clearance. And COVID allows me to do that without violating the Americans with Disabilities Act.
Great. And our final question on this employment law, Bill, we'll go back to you, and I think Steve may have some comments to share on this. But as we all go back to work, it's going to be allergy season, and many suffer from seasonal allergies. What can an employer do to get a level of comfort that my employees just have allergies and are not coming to work ill with COVID?
That is that's the question of the hour. I wish I had a hard and fast rule with respect to that. I think as we progress, again, the CDC is the storehouse for this information about what symptoms we should be following going forward. Again, echoing what Steve said, OSHA and the Pennsylvania regulatory laws that apply in workers' compensation situations require that the employer provide a safe workplace. I think one of the things that will come out of this pandemic is that employers will become more strict with respect to sending employees home. One of the things that Steve mentioned was influenza. Again, not to minimize the impact of COVID, but influenza impacts and really more people die of the flu on a yearly basis than would COVID in any given year. Now, maybe a lot of those people aren't active in the workplace. They have other health conditions. That seems to be a corollary in both situations. But employers are going to have to be more vigilant in sending people home who are visibly sick. Maybe we won't be taking the temperatures of people who come into the office every day in August, September, October. But, September and October, that's when people start getting flu shots again. So we're kind of right back in the game. But I think employers are going to have a new sensitivity to sending people home. And we're going to have to be more active. We're going to have to tell an employee, hey, look, I understand you want to be at work. You're sneezing, you're coughing, you're obviously, we can hear you breathing. You obviously have a respiratory impact. Let's do everyone a favor, including the employee, or doing the employee a favor, and work from home. Start making those accommodations as soon as possible, because we're now all beginning to understand how these things can move in the workplace quickly.
And in that same regard, if an employee takes a few days of sick time to recover from a cold or seasonal allergies, may the employer require a COVID-19 test before returning to work?
I think you would have to have specific information that would lead you to believe that the person had or was exposed to COVID. And in fact, if you had reason to believe that the employee was exposed to COVID, either because statements were made about what's going on outside of the workplace or just activity that has gone on in the workplace, that's definitely a possibility. You can have someone have a return to work fitness test, just like you would if an employee had injured their back on the job, or had carpal tunnel syndrome, or had suffered a head injury, God forbid, and had a concussion. You would want to make sure that that person was medically cleared to return to work. And again, like Steve said, we would use some of the things that we were using pre-COVID to also accommodate COVID. So I would suggest the the fitness to return to work protocol.
Great. Steve, do you have anything you'd like to add on either of those pieces?
Just that, as Bill and Eugenia said earlier, this is the time to look at our documentation and to update it. And that would cover a number of the things that Bill just pointed out. If we have good documentation on our policies and we apply them properly, then we're able to sustain legal challenges and compensation claims. And that's the important thing. We don't want to overreact to COVID with a bunch of policies that would apply just to COVID, but we want a gap fill in our employment policies.
Great.
Thank you.
Thank you so much. And now we're going to move on to group health benefits. If you have questions, please type them into the chat. We won't get to them today, but we will have a wrap-up session with all of our experts on Friday, same time, and we will answer your questions then, but that will give them some time to prepare if you ask them today. Colin, we're ready to move on to you. Are you ready for our questions?
I am.
All right, great. So first and foremost, may an employer pay the employee's health benefits while the employee is furloughed?
The short answer is yes. Quite a few carriers have lightened up their requirements as far as eligibility, payment, furloughed employees, laid off employees, and it all depends on the carrier. Again, this business is driven by obviously thousands of carriers that are out in the marketplace. Our experience has been, and we've had a few large clients have to lay off hundreds of people, and all the guidance that we've been receiving points to the fact that, and it's the last sentence in every single guidance bulletin we get, and they all read the same from every carrier. And they say, as long as the premium is paid. So they're very flexible, go figure, as far as that goes. And the carriers have taken, most of the health carriers have taken a stance of non-enforcement, as far as they really don't care where the money comes from, as long as the money comes. And the same thing with eligibility, which a lot of folks are like, well, am I still going to be eligible that I'm not working? Because carriers have very strict eligibility guidelines as far as how they view employees who can go onto a plan. Those typically have been waived for most of the carriers that we deal with through June.
Great. In that same realm, how can an employer maybe collect, or should an employer be collecting the employee's portion of the premium at this time? So a lot of our group health benefits are split. The employer's paying a portion and the employee pays a portion. If that employee is furloughed and is only possibly receiving unemployment income, how do you go about that? Or what are you suggesting to your clients?
It's going to vary obviously from situation to situation, because not every employer is in the same financial situation right now, especially with the COVID. So what we have seen and what we're recommending is being as flexible as possible with your employees, working anything out that is acceptable to both parties. And especially in the smaller spaces, that's not a difficult task. A lot of employers are saying, hey, we understand, we're going to continue on for the time being, and get us your portion as you can. Others are saying, we're going to take it out of your vacation pay, we're going to take it out of your PTO, we're going to take it out of whatever other means they can. Others are just kind of freezing everything they can that can afford it. So it is a case-by-case situation. If anyone has specific questions on that, we'd be happy to go through the entire situation with them, and kind of do an analysis for them so that they're compliant and that they're getting paid.
Great.
It is a difficult one, though.
Thank you. Is there any relief, and I think you alluded to this earlier, but is there any relief from health insurance providers in regard to premium payment?
Well, and again, all the questions that we're getting these days don't have simple yes and no answers typically because of the situation. It's uncharted waters for everybody. I know of one carrier specifically in Pennsylvania, health insurance carrier, that has come out and said, we're going to just basically freeze payments for our clients temporarily for a period of 30, 60, 90 days. It depends on the situation. And that client would need to speak to their account manager specifically, which means if they have a broker consultant, they should be speaking to the broker consultant. The broker consultant, depending on the relationship with the carrier, it should be a good relationship, hopefully, can work that out with the account manager on a case-by-case basis. Typically, what they're saying is, right now, and again, the majority of the carriers, and Highmark especially, has been very flexible in the manners that between now and June 30th, they're trying to express in written and verbal form how flexible they're willing to be, without coming out and saying, "Hey, don't pay your premiums," because we know we're never going to hear that from an insurance company. But they are saying, "We understand. We'll look at things on a case-by-case basis." They are stressing to people as well that for in the small space, those folks can now pay their premiums with a credit card. Now, I know a lot of businesses have company cards and corporate cards. And if that's an option for them, what I recommend to our clients is, and they're also allowed to use the grace period, which most people in our space of benefits don't like to ever live in that grace period. Some do. They do it by habit. Others are like, no, I don't want any problems in case there's another hiccup down the road during the grace period that could really sink me. So the carriers are stating, though, that if you want to use the grace period, by all means use it. Grace periods are 30 days. And I know Highmark gives an extra 15 days on top of the 30 before they're not going to turn your coverage off, before it starts to get real, before they start saying, okay, at the end of 45 days, they'll send a letter exclaiming, this is where we're at. Can we help in any other ways? If you're going to do something like that, or if you have to do something like that, what I recommend is use your grace period in a small space. Use your grace period first. If you just can't afford the premium, use your grace period first. And if you can, then use your credit card, because that's going to buy you another 30 to 45 days, and depending on the terms you have with your credit card company. And if you want to do that whole balance transfer thing that some folks do, you can do that as well. But I will go back to my original statement where carriers are very flexible right now when it comes to this. They don't want to lose customers. They understand the situation. They're not going to come right out and tell people, no, don't worry about it. We don't pay us when you can. That's never going to be done.
Of course.
But they want to have a conversation about it.
Of course. And Colin, you're so good that you just answered my next two questions. So those were regarding what is the grace period. So you talked about the 30 days and possibly longer. Again, talk to your carrier. And then, can I pay my insurance premiums on a credit card? So you answered those two questions. So I'm going to keep moving forward and
Right.
wrap up this call. But what should we be doing now, if anything, to ease the financial burden of the possible rising health insurance premiums after this is over?
Great question. And again, not a simple answer, but planning is everything. And like Steve and Bill had exclaimed, planning now, documentation now, like doing things now, when you have all this free time to plan for something that no one could have planned for this in the past, really. Maybe somebody could have, but no one saw this on the horizon. So this is very valuable time to lock things down and to get your policies and your procedures in place. And that being one of them. I've got one client. We have a client, I should say, that all year long, he puts 0.5% of his net profit into a separate account, just for a situation, not a COVID, but for a rainy day fund, let's say. So he is in a situation where they can pay their premiums for their employees for the next 120 days because he did that. That's one little thing. It's kind of like a Christmas fund for health insurance premiums for the future. Another thing is to review how you're handling contributions currently. A lot of employers in situations like this will change from where they pay the premium a month in advance and then take it from their employees to a situation where they, as soon as an employee comes on board, they start to extract from their paychecks for health benefits ahead of time. So the employee is always paid ahead. So that gives them a little wiggle room as well with that. As far as the carriers go, they're, like I said, flexibility is the name of the game right now, and they're all trying to be as flexible as possible when it comes to that. There's so many different options right now in the marketplace for funding health insurance. When this first hit, the bulletins and the guidance we were getting was telling us that this was going to be catastrophic for health insurance rates in the future for third quarter, fourth quarter, especially fourth quarter.
Sure.
And for next year's first quarter. They were saying it was going to be insane. Now, as of yesterday, that's reversed. Now they're saying, surprisingly, because the federal government aid and things that are coming in, surprisingly, they're looking at a decrease for first quarter 2021.
Well, that would be a relief for a lot of our small businesses that are facing this.
Yeah, and when I say decrease, we look at trend. They're looking at the trend, like how it always is for decades. And they're saying that trend, I hate to use this expression, but that curve is going to flatten a little bit for folks, which, thumbs up. We love that.
Right. I want to, because I think this is a very pressing question. Can we bring our employees back onto our health plan without satisfying a new waiting period after all of this is over?
Very good question. We're getting a lot of that. I've gotten that question probably, I would say, a dozen times just this week. Short answer is depends on your carrier. However, all the guidance that we're getting, again, not to say this over and over, but Highmark is very good at getting that information out, and anybody that has Highmark coverage, other carriers you have to deal with your carriers one-on-one, but they do not have to satisfy or resatisfy a waiting period up until June 30th. And that situation is whether they were laid off, furloughed, started, and then had to stop. They're being very flexible when it comes to that. And whether it's small group, large group, fully insured, self-insured, very, very, very flexible when it comes to that. So no, the typical answer is no, they do not have to resatisfy any kind of a waiting period. And that goes for the primary insured as well as their dependents. Because in this situation, a lot of folks saying, okay, I'm gonna take my dependents off. I'm gonna stay on just so we can keep the coverage. We'll float my dependents for now. We'll put them back on later. And if they do that for a strategy, the dependents do not have to requalify either for the waiting period.
Okay. Very good information. I have just a couple other quick questions here, and we'll try to get everybody off the call quickly. Our open enrollment period is coming up soon. What happens now? And Colin, we can defer that one to Friday if that's going to be a longer question answered. But go ahead.
It's up to you. I mean, we actually have a few of clients that I was just speaking with yesterday that theirs is coming up in July.
Okay.
And they're kind of asking, what are we going to do? The good news is, and I'll touch again on it on Friday, a little more detail, but the good news is a lot because of that and because of the situation that we're in, I know that all of the ancillary carriers that we deal with, that deal with all the ancillary lines, not your primary line of health insurance, but all the other benefits that you may or may not get or have, they're all saying, we're just doing a hold. We're going to hold our rates. We're going to hold everything for the renewals, forget increases. Everything is just the same as it was last year. We're going to extend that rate for one more year for you as a favor and as a little gesture of kindness, which again, I've been doing this for over 30 years and hearing insurance companies and seeing insurance companies putting these bulletins out. like my head's spinning around, like that they're not taking advantage of it, but they are, a lot of them are being very favorable when it comes to that. So far the ancillary carriers being very flexible. Some of the health carriers, no, they're sending out the renewals as if it was business as usual, which I'm in that fight right now with several of those carriers to stop that.
Well, good, and we appreciate you being an advocate for that. One last question, because I think some people are facing this right now, but what's the best option, COBRA or the ACA exchange, for employees who have been laid off?
Great question as well. Another great question that we're getting a lot of recently from our clients all over. This comes down to a little bit of personal, a little bit of professional opinion. And personally, I would choose COBRA just because it keeps my rights intact as far as the coverages that I have. Every situation is different. If someone is currently being treated for something, a pre-existing condition of any sort, and they have a doctor, they like their doctor, and they don't want any changes or upheavals or any kind of, bumps in the road, or they're on certain medications, and those medications they've already gone through their trial periods and they've gone through the step programs that some carriers have, depending on whether they're on an open formulary or a closed formulary with their carrier. All those questions have to be considered. There's no real simple answer when it comes to this either. Personally, I'm a COBRA fan. People think, oh, COBRA, it's like 10 times more expensive. It's not. It's the exact same rate that your employer is paying currently, with the option of an employer charging 2% as an admin fee. So if the premium is $500, 2% is $10. It's not a big deal. It's not like COBRA rates are $1,000 more a month. Sure. They're not. They're the same as the employer is paying currently for you. You're just not enjoying the co-share or the contribution from the employer on it. I think your rights are vastly greater with COBRA. Now, if you have to go to the exchange and you have to pick a plan, the majority of, if you're young and you're healthy and you're bulletproof and you cut half your arm off at work and wrap it up in duct tape and go back to work and it's healed in 2 days, go to the exchange. That's fine. Take the highest deductible you can. Like, that would be my recommendation. If you're young, healthy, bulletproof, built of Teflon, not a problem. Save that money. If you're not, and if you've got any kind of conditions going on, anybody in your family has any kind of medical conditions, COBRA will buy you that 18 months leeway time and do what you can to keep your coverage solid. There's a lot of upheaval in that their ACA marketplace right now, besides the rates being ridiculously high. And granted, the younger you are, the better it is, the cheaper the rates. And depending on your income situation, you're going to pay a heck of a lot less for that coverage if you get a subsidy. Now, with the added, and again, I can do some of this Friday, I don't want to take up all the time, but with the added unemployment money from the government, the $600, that could throw a monkey wrench in your subsidy, and you could end up paying more for the ACA coverage than you would for the COBRA.
Okay. And I think that's a good spot to kind of end and know that we can elaborate on that a little more as our employers might have questions coming in from their employees regarding that.
Sure. I have a little secret I'll tell everybody on Friday about COBRA too, as far as getting COBRA, maintaining COBRA. There's a little secret I'll tell everybody on Friday that a lot of people don't know, that will be very helpful.
Well, very good. We'll look forward to that secret on Friday, and hopefully everyone will be able to join us on the call. Again, I want to thank Bill and Steve and Colin for being on the call with us today. This is the site where you can go. Again, just go to wyccc.com. Big box pops up, says COVID resources. Click on that box. You'll see this Restart, Rebound, Rebuild logo. Click in there and you'll get a whole list of our upcoming webinars, as well as the recordings of our webinars with the information and resources mentioned in each of the video. So Monday's call is up and live. I just didn't update this screen, but Monday's call is up and live, and the resources mentioned today will be sent to us, as well as I will link the websites for our speakers today. And then this is our upcoming schedule. So next week, we will be talking tax credits and accounting, and possibly, and this one may change, but workspace sanitation with the new CDC guidelines. And then again, Friday, we'll wrap up those calls. If you have a topic that we haven't covered or isn't on our upcoming list and you think it is important for us to get to sooner rather than later, please let us know. I spoke with a banker this morning and we talked over some of the things coming up with PPP and forgiveness. So we may try to squeeze that in next week if that is something that we can get in, but I think that that's imperative for our members. So if you are seeing something coming up in your workplace that you feel is imperative to other employers and you want us to cover that topic, please let me know. Again, thank you to Colin, to Bill, and to Steve for being on the call today. I appreciate your time. I appreciate all of you taking the time to spend your mornings with us. And if you have anything you want to share, please email me. It's just gina@wyccc.com. Thank you for joining our Restart, Rebound, Rebuild series, and stay safe, everyone. Have a great day.
Thank you.